Good morning, everyone. Violating my own rule, forgetting to shut down my Outlook notifications. Apologize for that. Welcome to our third Zoom arguments. We have two cases scheduled for this morning. We are grateful to counsel for being willing to participate in the argument this way. It's helping us keep current on our docket. We know it is not what you're used to, and so we're grateful that you were willing to do that. Each of the cases this morning is a mini oral argument on the application. That means each side has 15 minutes, but the way we'll proceed in our Zoom courtroom is the appellant will have 5 minutes, and then I will turn to each justice for questions. You can reserve time if you like, Ms. Hurwitz, but that'll be up on you. And then Mr. Allen, you will have 5 minutes, and I will turn to each justice for questions as well. So with that, we'll call the first case, Sanford versus the State of Michigan.
Thank you, Your Honors. May it please the court, my name is Julie Hurwitz, and I represent the plaintiff appellant Devontae Sanford on this application for leave to appeal. For the record, I'm waiving my free fire time, so if any questions arise and you want to interrupt me, please feel free to do so. The single question presented by the court on our application is whether the plaintiff is entitled to compensation under the Wrongful Imprisonment Compensation Act, or WICA, for time spent in a juvenile detention facility before he was convicted of a crime. Using the court's well-established principles of statutory construction and looking at the plain language of the WICA statute, the answer to that question is unequivocally yes. Those who were wrongfully convicted are entitled to be compensated for the full amount of their wrongful imprisonment. And the introductory language to the statute itself, section 1751, states in no uncertain terms that this is an act to provide compensation for individuals wrongfully imprisoned for crimes they did not commit. It does not say wrongfully imprisoned in state correctional facilities for crimes. It says wrongfully imprisoned. So really the essence of this question before the court is how the word imprisoned or prison or imprisonment are to be defined and understood within the context of this statute. WICA is a remedial statute. That is, it is designed to correct existing law, redress existing grievances, or introduce regulations conducive to public good. And as such, it is to be interpreted broadly to advance its purposes. So the court must liberally construe the statute's provisions in favor of the persons who are its intended beneficiaries. And in this case, the WICA statute is explicitly intended to compensate people who were wrongfully convicted and wrongfully imprisoned for crimes they did not commit, as occurred to Mr. Sanford in this case. Basic principles of statutory construction require an understanding that in order to compensate Mr. Sanford for the time he was wrongfully imprisoned, it must encompass the full amount of time for which he was actually imprisoned. And if you look at how WICA is set up, it's really a two-step process. Section 1753 and 1755 of the statute provide both the general overview of when a person may bring an action for compensation and what must be shown in order to trigger eligibility to bring a cause of action under WICA. Under that first prong, or the threshold provision of the statute, there are certain things that must be established. One, that the plaintiff was convicted, that he was imprisoned, he was sentenced to time in a state correctional facility, which is specifically defined by the statute, and that ultimately evidence arises after the conviction to prove that the plaintiff was actually innocent. Once that threshold requirement is met, Then the court moves to the second prong of the statutory, section 1755, which then sets forth the criteria for calculating the damages to which the plaintiff is actually entitled. And in that section of the statute, at no time is there any requirement or even language within that statute that requires a showing or that limits the scope of compensation to time spent in a state correctional facility. What is
I'm going to interrupt you because you invited me to. The logic of your argument is easy to understand. It does seem incongruous that if somebody spends the majority of their time in something other than a state prison, that it's not compensable, especially since it's not the state. The purpose of the statute is not to right a wrong done by the state. Most people are convicted by counties. But the language of the statute in sub 2, which requires that if the court finds that a plaintiff was wrongfully convicted and imprisoned, the court shall award compensation as follows. Does the imprisoned in that subsection, in that language, tell us anything about what imprisoned might mean throughout the statute?
I think not, Your Honor. I think that the word imprisoned should be understood as it exists within that section of the statute. And as the court knows, statutory construction requires paying close attention to words that are in the statute, in one section of the statute, and the omission of those particular words in other sections of the statute should be taken very seriously. And it's well settled that when the legislature saw fit to use a phrase or a word in one section of the statute and omit that phrase or word from another section of the statute, that was intentional and that it has significant meaning. And the absence of any reference to state correctional facility in section 2 of the compensatory scheme for this law is very significant. And when you look at how the word imprisonment or prison, is defined, there are two very important points that I think should be made. One, the statute defines state correctional facility. Nowhere in that definition does it use the word prison, imprisonment, or imprisoned. It also does not define those words in the statute. So in order to understand the meaning of the words prison or imprisonment, one looks to other sources, such as that.
Let me interrupt you and get to my other colleagues to see who else has questions. Justice Markman.
No, thank you.
No questions? Justice Zara.
So following up on the Chief Justice's question, I understand both litigants' interpretive arguments, and while they're reasonable, we must employ some method of interpretation to lead us to favor one interpretation over another. Along these lines, I took a look last night at Scalia and Garner's Reading Law, the reference book that talks about canons of construction, and I came across a couple of canons that may be applicable. Using the series qualifier canon, I tend to conclude that the word wrongfully in MCL 691.1755 subsection 2 modifies both the verb imprisoned and the verb convicted. In other words, you must be wrongfully imprisoned and wrongfully convicted. I assume that you don't have any problem with that aspect, correct, Ms. Hurwitz?
Not at all, Your Honor. In fact, I totally agree with that.
Okay, so now we get to another canon, the scope of the subparts canon, which provides that the text of a statutory provision applies to all of the subparts that follow or precede the unindented text. So looking at this statute, again, looking at 691.17552, beneath it we find subpart A. Would not the word wrongfully that modifies imprisoned in in section 2 above, also modify the word imprisoned in subpart A? In other words, in order to be compensated, it must be a wrongful imprisonment. Do you take issue with that?
In order to be compensated, a person must have been wrongfully imprisoned. That's correct.
But subpart A talks about exactly what you're being compensated for. And I guess the question I have is, when it's pre-conviction, is that detention wrongful?
Absolutely. Once a person has been determined to have been wrongfully convicted, every moment they spend locked up and deprived of their liberty is wrongful. In fact, I think a useful source to refer to is the jail credit statute, which specifically treats pretrial detention as part of the sentence that was handed down once the person has been convicted. And based on the plain language of the jail credit statute, you only have to look back at really the first day of the imprisonment goes back to the first day of incarceration, which was when Mr. Sanford was arrested and placed in the juvenile detention facility. And I might add, in reference to one of the points that the state makes in its brief, it refers to a number of statutes which it has argued are analogous, which we strongly urge the court to look at those statutes, because every one of them actually helps, supports the plaintiff's position here. But by example, I would simply refer the court to the Code of Criminal Procedure, MCLA section 761.1, which is specifically relied on and referred to by the state and the defendant here for the purpose of showing that somehow or other jails and prisons are considered to be different things. But if you look at the language of 761.1 and you look at the, I apologize, I'm reaching for the statutory language and can't find it, but it also defines jails and prisons. In section 761.1H, a jail and a prison are considered to be similar words which specifically and explicitly include juvenile facilities in which a juvenile has been placed pending trial. So when you look at the plain language of the statutory use of words here, prison, imprisonment, and imprisoned, which are the words that are used in section 2 of 1755, one really need only look at any dictionary definition of prison, imprisonment, and imprisoned, and even the analogous statutory language that the state here is asking the court to refer to supports the interpretation of jails, prisons, jail isn't even a word used in WICA. And the state continues to try to distinguish between jails and prisons. That's completely irrelevant to the determination here that the court must take. And I see that I only have 2.5 minutes left, so I'm gonna wrap up and reserve the rest of my time if I may. I would like to say, however, that the Court of Claims and the Court of Appeals in this case should be overturned because we believe it engaged in an improper exercise of
Ms. Hurwitz, I'm gonna interrupt you because I'm gonna give every one of my colleagues a chance to ask you a question, even though we have used up your time. So let me move to Justice Viviano, please. You're muted.
Okay, sorry, I didn't know I had to unmute myself. All right, so I have just two quick questions, counsel. One is, aren't you asking us to give imprisonment a different meaning in section 2 than we would give the term in section 1? Subsection 1, I should say, of the statute. Isn't that an unusual sort of interpretive thing for us to do?
No, Your Honor, because in section 1, the word imprisoned is accompanied by the phrase in a state correctional facility. That's the threshold criteria. In section 2, the word imprisoned is left alone. It's completely standalone.
Why wouldn't we think of that as the second reference and the references throughout subsection 2 as just a shorthand for the entire phrase that appears above. But wouldn't that be in sort of an ordinary mode of interpretation?
I don't believe so, Your Honor, because if the legislature intended to limit the term, the scope of compensation to imprisonment in a state correctional facility, they easily could have and should have included that phrase in that section, and they chose not to. And imprisonment is a much broader term. The idea, the whole purpose of WICA is to compensate someone who's been wrongfully imprisoned for a crime they didn't commit. And Mr. Sanford was wrongfully imprisoned from the moment as a 14-year-old child, he was placed into this juvenile detention facility. And I have 25 seconds left and really want to reserve some rebuttal.
Well, I apologize. And you're going to be, I think, questioned maybe some more by my colleagues. But my last question is, your view is that imprisonment is a broad term that encompasses the state prison, time in the state prison, time in the county jail, pretrial detention, time in the juvenile facility, etc. I just I have one more question. If the term is so broad, why do you think in subsection 2A, the legislature changed to using the word incarceration, which it used twice in one sentence? And I think it's the only time it used the term incarceration in the entire act. So why if imprisonment was broad, why didn't it just use, for example, for imprisonment of less than a year in prison, as opposed to for incarceration?
Well, Your Honor, I think that imprisonment and incarceration actually mean the same thing. And again, I refer the court to the dictionary definitions of both of those terms and analogous statutory use of those terms. Every single time that the legislature has seen fit to limit the scope of the word imprisonment, they accompanied it with in a state correctional facility. State correctional facility, nowhere in any of the definitional languages that any statute uses, including WICA, does a state correctional facility use the word imprisoned, prison, jail. It's a facility. And the only difference between a state correctional facility and any other kind of prison is that a state correctional facility is run and operated by the Michigan Department of Corrections. If you look at every single statutory definition of jail, of state correctional facility. So imprisonment and incarceration are, for all intents and purposes, identical if you go to the sources for understanding what those words mean.
Thank you, counsel.
Justice Bernstein. Can somebody unmute Justice Bernstein, please?
Good afternoon, counsel. Chief, if it's okay, I would like to let Justice Clement go before me, and then I'll ask a question after she's concluded.
He's playing that trick on you again, Justice Clement. Justice Clement.
I don't have any questions. Thank you.
Oh, she got you back. Justice Bernstein?
Okay. Well, counsel, seeing that I don't think you're going to have rebuttal time, I'm going to ask you a pretty sweeping question that I'd like you to take your time to answer. And it's going to be more of a commonsensical question. If the idea of this statute was designed to make sure that people who are wrongfully convicted would be able to receive compensation from the state, the whole idea is here's a person who is completely innocent, who lost years of his life. What possible reason would the legislature have to exclude jails and to exclude juvenile detention centers? If the concept of this is to try to make this circumstance that someone is compensated for the life that they have lost because of the state's action, why on earth would the legislature make such an exclusion to jails and to other services, to other places where people are incarcerated against their will? Doesn't it just defy a sense of common sense?
I completely agree with you, Your Honor, and I would suggest that that is a question better asked to counsel for the state of Michigan, because I actually, as I have researched this and understand the principles of statutory instruction in combination with what we understand the underlying purpose of WICA to be, is to provide compensation for individuals wrongfully imprisoned. There is no logical explanation for how the legislature, for even suggesting that the legislature would deprive full compensation to someone who's wrongfully imprisoned. In fact, hypothetically, one can envision a situation where someone who doesn't have the wherewithal to post bond is arrested, is placed into pretrial detention, sits in pretrial detention for sometimes years before they are finally brought to trial, and then wrongfully convicted, sentenced to a term of imprisonment, being credited the full time of years that they've already served, and then sent to a state correctional facility for the remainder of their sentence, which in some instances may even be less than the time they've already served. And to suggest that that person shouldn't be entitled to full compensation for the entire term of that time that he was sentenced and ultimately was imprisoned really does defy logic, common sense, and what we believe was the full intent of the legislature.
Mr. Allen, I think you just got a preview of a question you might get from Justice Bernstein. I'm going to go to Justice Kavanaugh.
I just have, Ms. Hurwitz, do you, is it your position or that you think the word imprisoned in the statute is ambiguous?
Not at all. I believe that the word imprisoned means what it means and means what it says. And again, I refer the court to all of the various sources of definitional language that the word imprisoned, how it has been defined both by this legislature in other statutes, as well as by a number of well-respected dictionaries, as well as by the United States Court of Appeals for the Sixth Circuit in U.S. versus Goines, as well as a case that was recently decided by the U.S. Supreme Court, U.S. versus Mont, which unfortunately we didn't cite in our brief, but if we have an opportunity to fully brief this case, we certainly will, and we will discuss it. Every court that has examined the definition of the word imprisoned has consistently agreed that it encompasses both pretrial and post-conviction time of incarceration.
So the use of the word imprisoned or imprisonment is qualified in subsection 1A by the phrase, the defined phrase, in a state correctional facility. And it's telling that that same qualifier is not included in 2A when determining the amount of compensation.
That is correct. And it's, as I said at the beginning of my argument, it's a two-pronged approach. The statute first requires a showing of eligibility to even bring a cause of action. But once that threshold level has been met, the full scope of compensation must be afforded to a person who has been wrongfully convicted because he is innocent and wrongfully imprisoned for the entire time of that wrongful imprisonment.
Okay, thank you.
Thank you, counsel. Mr. Allen, Ms. Hurwitz used up most of your time, so you have like 3 minutes. I'm kidding. You may begin. You may proceed.
Right. Thank you, Your Honor. This is Chris Allen, Assistant Solicitor General on behalf of the state of Michigan. The Department of Attorney General holds responsibility for handling claims under the Wrongful Imprisonment Compensation Act, WICA. And since enaction of the act in I believe, March of 2017, we've paid out several claims in full, agreeing to millions of dollars of compensation for individuals wrongly convicted of crimes. In many cases, like this one, we've agreed that a plaintiff was entitled to compensation in our first responsive pleading. In short, the state is not looking to minimize the recovery for individuals who were wrongfully convicted. We want to pay what we owe. But consistent with that, the state is bound by the terms of the statute that the legislature created. As with any bill, it's not perfectly drafted. It went through, I'm sure, a series of messy compromise. But the state is not here in the spirit of an adversary, but in trying to get the law right and trying to get the math right for the law. And so at the outset, I think in response to some of the discussion with Ms. Hurwitz, I'd like to note the limited scope of WICA. It was not written and it was not intended to correct all the wrongs of wrongful convictions in the state. It does not cover individuals who are innocent and sentenced to a jail term. That's just plain by its language. It does not cover people who were held pre-trial but ultimately found not guilty. It does not compensate those who actually are innocent and serve time in prison but do not have any new evidence to prove it. It limits the amount of compensation to $50,000 a year, and it makes no provision for individualized damages, which I have to imagine would be much higher for being imprisoned for a crime you didn't commit. So in the end, WICA is a relatively narrow statute designed to compensate a certain subset of individuals who are wrongly convicted and sentenced to a term in the state prison. And I think that's why the crux of a WICA claim is the wrongful conviction and a, quote, term of imprisonment, end quote, in a state correctional facility. And drawing this line was a reasonable choice, I think, by the legislature. That is, after the state has wrongfully stripped an individual of his presumption of innocence and subjected him to a lengthy term of incarceration. That's the universe of individuals that this act is concerned with. And although Mr. Sanford lost his liberty in the lead up to his plea, the purpose for that was public safety. He was accused of and convicted of and exonerated of a really heinous crime. And at the time of arrest and the time of holding him pre-trial, not all the facts were known. After conviction, however, he's adjudged by the state to be guilty. His presumption of innocence is gone. And it is the consequences of that harm that the WICA was designed to address. And that understanding, I think, is reflected in the elements of the claim, both in Section 4, which is kind of the pleading requirement, Section 5.1, which is contains the elements of the crime, of the cause of action, excuse me, that really hinge on, I think the linchpin is the wrongful conviction and wrongful sentence to a term in a state correctional facility. And so what we're discussing here is Section 5.2, which immediately follows 5.1. And 5.2 states, quote, if a court finds that a plaintiff was wrongfully convicted and imprisoned, end quote, which to my mind clearly references the substantive elements of the cause of action, wrongfully convicted and imprisoned. That is the shorthand, I believe, as Justice Viviano put it, for the package of elements that's immediately preceding 5.2. Because the court's not, a trial court here is not, the Court of Claims is not just determining by its own accord who was wrongfully convicted and imprisoned. That's the job of those elements, the immediately preceding section. So in Section 5.2a, the following subsection, it states, if the court finds that a plaintiff was wrongfully convicted and imprisoned, the court shall award compensation as follows, and then it discusses the start date, kind of this compensation formula, which is the date the plaintiff was imprisoned. And so imprisoned is used in what is effectively the same sentence twice. And I understand the plaintiff's argument to essentially mean that we would interpret the second imprisoned much more broadly than the first one. And I think there are several contextual and textual arguments here, but I think that's one that really meets the contrary argument from the plaintiff that throughout the statute, state correctional facility is always attached to imprisonment. And therefore, because it's omitted here, it means something totally different. Well, I think Section 5.2 really.
Your 5 minutes is up. Let's get to questions. Can you help me with what we should think of Section 1A's inclusion of in a state correctional facility? I feel like I feel like I'm looking at one of those people looking at that dress on the internet and seeing it as white and gold, and some people see it as blue and gold. I mean, it's like, to me, was sentenced to a term of imprisonment in a state correctional facility sounds like you could be sentenced to a term of imprisonment somewhere else. right? Like a county jail or a juvenile facility. So in addition to the statute defining in a state correctional facility, why shouldn't I think that that plain language means you can be sentenced to a term of imprisonment in more than one place? And doesn't that therefore inform how we think of the word imprisonment in other parts of the statute?
I believe I understand your question, Your Honor, is suggesting that in a state correctional facility, as modifying imprisonment there suggests that without the modification, imprisonment means something substantially broader. And I think that I'm not contending that imprisoned or imprisonment can never mean something broader than time at a correctional facility. I think, there are crimes, false imprisonment. You can imprison someone in your bathroom. So it's not the case that we're not making the case that imprisoned necessarily means in a prison. I think our argument is more that as a default, the vast majority of interpretive sources suggest that it is this narrower term. And so unless tethered to a modifier like in jail or in a pretrial detention facility, imprisonment, the default essentially is prison. And so in a state correctional facility, language isn't so much a necessary piece of defining what imprisonment means in itself, but it provides more context for what that means. It's being a bit more specific, I suppose.
Okay.
And so I guess that gets back to your characterization of this as, the bluegrass or the gold dress. But I think that might not be solvable. But here, I think because imprisonment has a kind of standard meaning, and throughout the rest of the act, it's pretty clear that the requirement means a showing that you have to serve time you have to be sentenced to a term in state imprisonment. Therefore, that meaning carries throughout.
Thank you. Justice Markman.
Can you hear me now?
Yes, Your Honor.
We can hear you. Yep.
I'm sorry I couldn't be heard when Ms. Hurwitz was speaking. I tried raising my voice several times. It didn't help very much. But I have no further questions for Mr. Allen at this time. Thank you.
Thank you, Justice Zara.
Mr. Allen, are you taking the position that your interpretation is drawn from moving the word wrongful in section 5.2? You prevail because we take the word wrongful in 5.2 and we move it down to 5.2a? Or are you taking the position that you prevail because state correctional facility found in 5.1 is moved down to 5.2 and 5.2a? Or is it both? Is it one, the other, or both?
I believe predominantly it's the second piece, that wrongfully convicted and imprisoned is essentially shorthand for showing the elements of the cause of action. And so if a court finds that the plaintiff has met his proofs, then he is determined to have been wrongfully convicted and imprisoned. And therefore, use of imprisoned, both in section 5.2 and 5.2a, has this consistent meaning of a term of imprisonment in a state correctional facility. And I think that's buttressed by the second sentence of 5.2a, which again, the statute uses different ways of apparently referring to the same thing, because the second sentence says for incarceration of less than a year in prison. So that uses a different word, incarceration. It points out the specific place that you're entitled to for incomplete years, I suppose, pro rata amount. Why the legislature saw fit to use a different language there, I'm not entirely sure, and I don't have a great explanation for that. But again, it's consistent with the understanding of the first sentence in 5.2a and also just 5.2 itself.
Thank you.
Justice Viviano.
Okay, this time the host unmuted me. You guys are playing tricks on me. Mr. Allen, so I guess just to be clear, it sounds to me like your argument, the position you're taking is that the ordinary meaning of imprisonment is broad. It sounds like you're agreeing with your opposing counsel that the ordinary meaning of that term is broad enough to encompass more than just confinement in a state prison.
I disagree, Your Honor. What I intended to say was that the default meaning of imprisonment means in a state prison, in a prison facility. That's
what exactly makes that? I have two questions. One is what is the? I don't know why we're interested in a default meaning as opposed to the ordinary meaning of the term as it's used in the statute. And number two, why is that the default meaning in any event?
Well, when I say default, Your Honor, what I mean to say is I don't dispute that imprisonment in a different context could mean something more broad when it's tethered to another modifier. Imprisonment, I mean, many words have multiple definitions. But as we understand what prison and imprisonment mean in Michigan criminal justice system, for all of the sources that we set forth in our brief, whether it's court decisions, ordinary usage, the jail task force, I think, is a strong indicator that prison means a particular thing, jail means a particular thing, and then so as the root of imprisonment, prison has this as an ordinary matter. If you were to just say that word, that the default again is the narrower understanding. That's not to say that it can't bear a different meaning in a different context with different modifiers, but standing alone, it is a narrow term. But again, that's not
the dictionary. And the dictionary says imprison is to confine in or as if in a prison. That's not a broad. I understood your argument to be that it's a broad term, but when we look at the context of this statute, the legislature used it narrowly. Now you're saying that it's a narrow term that sometimes could be broader depending on context, but the default is narrow?
Your Honor, I'd like to think I've been consistent throughout, both in our briefing and the argument today, that yes, the plain and ordinary meaning is that prison is narrow. I think that's really pretty laid out pretty thoroughly in our brief. I'm just making a minor concession that if this were a different statute and imprisonment was modified or put in a completely different context or circumstance, it could bear the meaning that the plaintiff wants it to mean. But it's just not the case here, given the context of the statute.
Let me ask you this, the question Justice Kavanaugh asked your opposing counsel. Since you think the term unequivocally means one thing and your opposing counsel unequivocally means another thing, does that mean the term is equally susceptible to two meanings, such that it's ambiguous?
I don't think that it is, Your Honor. I think given the context of the statute, how it's used throughout, that it is not ambiguous. Looking at the sort of totality of the totality of WICA, the totality of the act, how it operates really from start to finish, informs what imprisonment means in Section 5(2)(a). And so I think there are multiple reasons why it's not equally susceptible to multiple meanings. I think it's relatively rare that is the case. But even if it were ambiguous.
Yeah, that's what I was just going to ask you. If it was ambiguous, do you lose?
No, Your Honor. And I think the tiebreaker, if anything, is how it's treated in the rest of the statute. Now, the plaintiff has argued that this should be liberally construed because it is a remedial statute. And I'm hard pressed to argue that it's not. But at the same time, it's also a waiver of sovereign immunity, which is to be strictly construed in the normal course. So if those sort of thumb on the scale interpretive canons are to be applied, I think they meet each other. And so we're left really, what's the best reasonable interpretation?
I sort of agree with your old boss that those rules, we really shouldn't apply those rules.
Well, Your Honor, and that was, I apologize, Your Honor, that was my next point is, in the McQueer case from 2018 from this court noted that it's inclined not to apply these kind of thumb on the scale canons of interpretation because they're really not needed. What we want to look at is the reasonable interpretation of the statute. So I'm not asking the court to construe it narrowly or broadly. I think however it is construed, the narrower construction is the one that's most consistent with what the legislature enacted here. If they wanted to establish a broad understanding compensate more people, compensate them for longer time, they surely could have done so. And if they decide to amend the statute and do so, we'll be glad to pay out. This is not as if we're trying to be misers here, but we believe we're only entitled to pay what the statute permits. And that's essentially our argument. Reading it in whole, it's a relatively narrow understanding of the term.
Thank you, counsel.
Justice Bernstein?
Yes, Chief, before we go on, I want to make a statement for the record because I'm actually a little concerned. I think this is important to point out. As a blind person, I'm not able to use Zoom, so I'm at an extreme disadvantage because of the fact that I cannot use Zoom because of its inaccessibility. And I just want to basically tell the court, I don't think there is any circumstance or situation where if a justice is asking questions where they are muted before they've indicated they have concluded their line of questions.
Oh, I apologize. I think that wasn't that was my fault. I think I cut you off to move on to the next justice. So I take responsibility and apologize for that. Do you have a question for Mr. Allen, Justice Bernstein?
I do have a question, but we can't ever, I would ask for the future that before mute is indicated, since there's no other way for me to communicate with the court due to my extreme disadvantage in this situation, that until the mute is put on, that I will indicate that my questions are concluded. I only have I have a few questions just for the state, and I'm going to ask the question which was posed to the state and posed to the plaintiff's counsel. And the question I'm going to pose is I'd like you to ask the same question that was posed to them, which is, again, you indicated that you're not trying to be miserly. However, this is a situation where you're talking about a $27,000 judgment for 198 days that this individual spent in incarceration in a juvenile facility. I guess my question is, you do have some discretion in terms of the cases and things that you do. Why is this so significant to you? Why is it so important that this person is denied their $27,000?
Your Honor, it's not, the $27,000 is a really no moment to whether we pay it or not. It's not the amount that matters, Your Honor. It's that the state is the one who has agreed to relief in this case. And for the state to agree to compensation that in good faith we do not believe that the plaintiff is entitled to under the statute, not as a matter of morality or of damage that he may have sustained surely while he was in jail, but the statute authorizes a relatively limited relief. And I think it would be beyond our power to authorize payment beyond what the statute permits.
So my last follow-up, though, is you had indicated, and this is my last question, and then I can be muted. The question I'm just going to pose back to you is that you had indicated in a prior statement that you had a circumstance where there's a number of people, if I misunderstood, please correct me, but that you had a number of people that you had indicated would be implicated by that. Is that correct, or did I misunderstand what you had said?
I believe what you're referring to, Your Honor, is in the introduction, the state has agreed to compensation for, I'm not sure of the number, but several individuals, and we've paid out in what we believe to be full for every day they spent in a state correctional facility. Some judgments were in excess of $1 million. This issue has not been raised in every case. I believe it's been raised in a case or two. And I think, if anything, that demonstrates that this is not an easy and obvious interpretation in the plaintiff's favor, because several other plaintiffs similarly situated have not pressed this issue, have not sought to have not read the statute in the way that this plaintiff does.
Thank you, counsel. I have concluded my question.
Thank you, Justice Bernstein. Justice Kavanaugh. I'm sorry, Justice Clement, skipped you.
Thank you. Counsel, I just have one clarifying question. So you seem to argue that nothing wrongful happens until the conviction. So I just want to be clear on when a wrongfully convicted individual is entitled to compensation. Is it the day that they're convicted? Is it the day that they're sentenced to the Department of Corrections? When do you see that point in time starting?
Your Honor, per the statute, the language states in 5.2a that the date the plaintiff was imprisoned, and again, with all the interpretive arguments informing what imprisoned means, at the point at which the defendant is convicted and sentenced. So at the time they're sentenced, they are thereafter under the jurisdiction of the Department of Corrections in prison. And that's how we've interpreted the understanding of when, the clock starts.
So what happens if you have a juvenile that's in a juvenile facility and is going to remain there for safety reasons for a period of time, and then not transfer to the Department of Corrections for a year or 2 years? Does that 1 or 2 years just not mean anything in terms of imprisonment?
Well, I think it would, I think at the point of sentencing, they are under the jurisdiction of the Department of Corrections. They are, essentially a legal fiction. They're serving time in prison. Now they may be housed somewhere per the Department of Corrections. And I'm not sure the specifics of whether, I'm not sure of the definition, whether if a juvenile is sentenced to a prison term and serves time in a juvenile facility, whether that is a prison. I believe that would still be a prison. It would be a juvenile prison, but it's not a county facility or the juvenile correctional facility. It would be distinct from the pretrial custody that this plaintiff was in.
Thank you.
Justice Kavanaugh.
Yeah, and I guess I just want to clarify and follow up on Justice Clement's question, because I had the same one. My understanding from the position you take in your brief is that, I believe I have this correct, Mr. Sanford was sentenced to a term of imprisonment in a state correctional facility, I think it was April 4th, and was taken into custody by the MDOC on April 8th. And my understanding of your position is that the date of compensation runs from that April 8th, meaning when he was physically in the facility or in their custody. And that's not exactly how I'm understanding your question, your response to Justice Clement. Here it was 4 days, but obviously, as she points out, it could be a matter of a year or 2 years or whatever that may be. So if we are to take, I think what you said in response to Justice Zara's question, the phrase from 1A and import that into 2A, then wouldn't the sentence to a term of imprisonment in a state correctional facility be the what we base our understanding of that they were imprisoned, the date? So wouldn't that be the date of sentencing, regardless of when they're physically in the MDOC? And I think that that's inconsistent with what you stated in your brief.
Perhaps I was unclear, Your Honor. The point at which the individual is in prison is when they've been entered into the jurisdiction of the Department of Corrections. I think that's the best, that's the clearest line to draw consistent with the statute. Now,
that's a clearer line, but that's not the term sentenced to a term of imprisonment in a state correctional facility, correct?
I agree, Your Honor, yes.
So if we're going to import what is actually stated in subsection 1 into subsection 2A, then we have to import sentence to a term of imprisonment, right? Which would be when the sentence is handed down, not when they are actually under the jurisdiction or taken into physical custody of the MDOC. So it's not as clear of a line, perhaps, as the position that you stated, correct?
Well, I think that is a clear line. I would agree, Your Honor. It's not entirely clear to me in the same way that it is post-conviction imprisonment as compared to pre-conviction incarceration, that the date on which the judgment of sentence is entered Sometimes that's entered the day following the actual sentencing hearing. But I think the line at which the Department of Corrections essentially has authority over the individual, that's when they've been imprisoned, consistent with it being in a state correctional facility, as we've discussed before.
And I have one last question, if you will. What, if anything, are we to take from some of the other provisions in the statute regarding, I'll sort of refer to them generally as set-off provisions and release, where it seems in subsection 9 and subsection 13 of 1755, there's talk of, a set-off that if a individual like Mr. Sanford had been obtained damages for a wrongful conviction or imprisonment from any other person, say the county or a police officer or whatever that may be, that this award is subject to set off for that amount, and that expenses incurred by any political subdivision of the state for housing and feeding and clothing the prisoner, those aren't subject to set off. And in general, those provisions seem to suggest that there may be, that these damages or the amount of the award encompasses something other than just time in a state facility, but that there may be other political subdivisions that either can't take a set off, or the plaintiff has to take a set off if they've gotten something from somebody other than the state. Do they inform what we mean by the measure of compensation in 2A?
I think, Your Honor, just for example, in subsection 13, which you referenced, it doesn't just say reimbursement for damages pertaining to the wrongful conviction. It says wrongful conviction or imprisonment. And so again, to use that term consistently throughout, I don't think it provides any contrary indication that the set-off potential for these types of claims has any, that the calculation for this damage under WICA is really any different. I think once you calculate what the plaintiff is owed, if there is a set-off under another act, we've had that circumstance in other situations where a plaintiff is recovered under, a federal action in 1983 or what have you, and we've come to an agreement about how to set off this amount against that amount. But I don't think that that informs the length of time or the compensation formula. At least I don't see any textual or contextual indication that would suggest one way or the other necessarily how to calculate the amount the plaintiff is entitled to.
Okay, so if Mr. Sanford had obtained a damages award from the county for time he spent in the juvenile detention facility or whatever, arising from his wrongful conviction or imprisonment, even though that this award from the state would be set off by that amount, even though the two don't overlap.
I hadn't thought of that kind of contingency before, Your Honor, but I think if it were the case that he was, if there was a settlement or a judgment for Mr. Sanford against, like you said, the county, and there was some kind of line item for how much, is for pretrial, how much is for post-trial, post-conviction, I think we would not be trying to set off that pretrial because of our understanding of how the statute works. Now, I don't think settlements or awards are often delineated like that. And so if the amount was substantially similar to what we have here, I would imagine there would just be some discussion with plaintiff's counsel about how to proceed. But if there really were a line item with pretrial incarceration for X number of dollars, we would not seek compensation. We would not seek offset in that circumstance.
Okay. And that would be a matter of practice, not necessarily the language of the setup.
Well, I think that would be consistent with our understanding of what the award here compensates, and because they're not overlapping, because they're not for the same they're not for the wrongful conviction or imprisonment of Mr. Sanford, therefore his wrongful or his pretrial detention, the set off under 13 wouldn't apply, I think. So it's not just a matter of practice, but that's how I understand it would operate legally.
Okay, thank you.
Thank you, counsel. Ms. Hurwitz, we used up way more than your rebuttal time, obviously, but I want to circle back to Justice Bernstein because we did not intend to cut him off. So I want to give Justice Bernstein a chance to ask you any additional questions that he had, because there's no reason why he shouldn't have been able to. Justice Bernstein, you want to proceed?
Yes, I mean, counsel, I'm going to give you an opportunity now to take the chance to respond to what was just stated.
The most recent statement made by Mr. Allen? Is that what you're asking?
I'm giving you the opportunity to basically, I'm giving you the opportunity to have a rebuttal. So my question back to you is there anything that he had stated that you'd like to rebut?
Well, yes, I would very much. Thank you. I would say that, again, I'm troubled or I'm perplexed by the position that I hear being taken that somehow or other the word prison or imprisonment has some generally understood definition that is limited to state correctional facilities unless otherwise accompanied by qualifying language, when all you need to do is look at every single dictionary definition of prison and every single analogous statutory definition of prison, and not one of them defines prison as a state correctional facility unless there's some qualifying language saying for purposes of this section only, this is what we mean. So I would very much urge the court to look at that language. And I do want to follow up on 2 points that came up during Mr. Allen's argument. One, the question from Justice Kavanaugh on when really does the date of compensation begin? Is it from the date of sentence or from the date of being taken into custody after the sentence? And when you, again, look back at the Jail Credit Act, once somebody is sentenced and they have been serving time in a pretrial detention facility, the date of sentence really goes back to the first date of imprisonment, which is the date of pretrial incarceration. So any way you look at it, it really, the legislative intent in this statute really does compel an interpretation that includes every day of actual imprisonment. And I'm a little perplexed by Mr. Allen's response to the set-off question, which I think is a very, very good question. And it's a good example of why it's so important to look at every word in a statute and understand the words that were used in each section of the statute. There is nothing in the set-off provisions that would allow the state to negotiate not requiring a set-off going back to whatever amount of money Mr. Sanford might receive in a civil rights settlement with, it's the city, by the way, not the county, but excuse me, under no circumstances can I imagine, and I've been doing this type of work for many years, that any settlement or jury award to Mr. Sanford for a 1983 case would separate out the time from pretrial to post-conviction. He would get one lump sum settlement, and no matter what amount of money he gets for the full amount of his imprisonment, he's going to be required to pay back the full amount that he received as damages under WICA. So it defies logic to suggest that under one circumstance, he's entitled to compensation for his full amount of imprisonment and will have to pay the state back for the full amount, and yet not be entitled to full recovery for the amount of time he was actually wrongfully imprisoned.
Thank you, counsel.
Thank you, counsel. I have no further questions.
Okay, thank you, Justice Bernstein.
The case,
oh, sorry, are you still talking, Justice Bernstein?
No, I just want to make it clear for the future that I have no further questions.
Thank you, Justice Bernstein. Thank you, counsel, both of you. We really appreciate, again, your participating in the oral argument this way. The case will be submitted. We will take a short break from the live streaming to get ready for the next case. It is 10:30 right now. We'll be back at 10:35.